Oh, has it just come off now?
Yeah. Okay, and good afternoon, everyone. We are here with Jack Swadling, Associate Solicitor from Silver Shermans Ash, who's going to be talking to us about what is concurrent delay. As always, if you could, and I'm sure you'll have questions for Jack, but if you could put them into the Q&A facility, which is in the bottom toolbar there, and then when Jack reaches the end of his presentation, he'll be happy to answer these for you. So without any further ado, Mr. Swadling, it's over to you. Take it away, please.
Thank you very much, Julie. Yeah, and thank you for everyone for joining us today. I have the perhaps unenviable task of giving a brief overview of the issues that arise out of concurrent delay on construction projects. And I think, needless to say, this is not a straightforward topic, and it's certainly not a topic where the courts have given very clear guidance as to how problems of concurrent delay should be dealt with. But anyway, the aim today is to go through, first of all, what is concurrent delay and how should that be understood, and then we will look at how the court has addressed problems arising out of concurrent delay with regard to employers' entitlements to levy liquidated damages and contractors' entitlements to extensions of time. And we will review the different authorities, and then following that we will have a quick look at the float built into programmes for works and how the courts have addressed ownership of that float, and a quick look at delay analysis techniques. Anyway, as Julie said, my name's Jack Swadling. I'm an associate solicitor in the construction team, specialising in construction disputes work. As you might imagine, quite a lot of this work comes out of problems arising from delay on construction projects and how those problems are addressed. So, first up, what is concurrent delay? Usually this is where one delay event is an employer's risk and the other is the contractor's risk as allocated under the construction contract. And the effects of those two events, so the employer's risk event and the contractor's risk event, are felt concurrently on the programme of works for a period of time. When the term concurrent delay is brought up in the context of disputes, typically it's in the context of it being a strategic defence, either raised by a contractor in circumstances where an employer is perhaps looking to levy delay damages or agreed liquidated damages under a construction contract, or otherwise a defence by an employer to a claim for an extension of time by a contractor. Now, in this talk, I'll refer to employer risk events and contractor risk events. An employer's risk event is what's typically referred to as a relevant event in the JCT talk. This is an event that occurs during a project which is agreed under the construction contract that the employer bears the risk for. So these fall under various different categories. But for instance, in the event of an employer instructing variation works, the delay effects of that variation would typically be borne by the employer, entitling the contractor to apply for an extension of time. And the manner in which different events, the risk of different events occurring, are allocated under the construction contract between the employer and the contractor is a key part of the risk allocation. under the construction contract. As I'm sure many of you would be aware, these the provisions for extensions of time under construction contracts are often subject to significant amendment. So it's always well worth reviewing exactly what delays you're taking on if you are a contractor, if terms are posed by an employer. Anyway, what is concurrent delay? We have a the term concurrent delay can actually refer to quite a lot of different situations, and I think that's perhaps the root of some of the problems in isolating what the actual effect of a period of concurrent delay is. We can think of it in this way. You have the causes of the delay, so this would be the relevant events and when they occur, and the effects of those delaying events. And you can have the causes and the effects being simultaneous or being sequential. Now, the way that concurrent delay is typically accepted is that it doesn't really matter if the events happen at exactly the same time. In actual fact, it would be very, very unusual for two events to occur at exactly the same time. What we are actually interested in here is what the effect of those events are on the programme for the works and the delay that they cause. In any analysis, it is always key to bear in mind that we are only really interested here on events that are causing critical delay to the work. So this is an event which means that the works cannot be completed by the completion date, rather than events that disrupt works under a programme and perhaps cause a contractor to incur additional expense but do not otherwise compromise the completion date. So it's only with reference to the completion date that we're considering the impact of these delay events. So concurrent delay, we're thinking of this in the context of it being a strategic defence. How's concurrent delay dealt with in the standard forms of contracts? This has been an issue that the courts, well, is a reason why the courts have had to step in and work out how concurrent delay should be dealt with, because the JCT forms and the NEC forms, which are perhaps the most popular standard forms of contract, just simply don't deal with concurrent delay. And how the risk of an employer risk event and a contractor risk event and the effects of those events being felt concurrently, and how that should be dealt with in terms of a contractor's entitlement to an extension of time. The most recent version of the FIDIC form has now brought in provisions to enable parties to expressly agree how concurrent delay is to be dealt with under a separate schedule. But, and there is nothing to stop parties agreeing amongst themselves how concurrent delay is to be dealt with by agreement. In fact, the courts only 2 years ago in the Court of Appeal in North Midland and Sidon have upheld a concurrent delay clause where the risk was placed onto the contractor, so it would not be entitled to an extension of time in circumstances of true concurrency. As mentioned, the courts in England and Wales have not been altogether clear in their approach on how to deal with true concurrency. I think it's really worth bearing in mind in this when talking about concurrent delay is it's often an argument that is raised by either an employer or a contractor, but it is far more unusual for there to be actual instances of true concurrency. Just before this talk, I looked at a good paper by Justice Coulson, which was published by the Society of Construction Law. And he said, concurrent delay is like a workable Brexit, regularly claimed to exist, but almost impossible to find in practice. And the reason for this is the reality is that in the large majority of cases, at any given time on a construction contract, there'll usually be one event that's causing the delay to the project as a whole. True cases of concurrent delay are extremely rare, despite them perhaps being regularly asserted in the context of disputes regarding entitlements to delay damages on the part of the employer and an extension of time on the part of the contractor carrying out the works. So in circumstances where it's quite unusual for the actual true concurrency to come up, it's actually quite unusual for the court to have to be dealing with these sorts of situation. But perhaps to think of a circumstance of true concurrency, it might be a situation where an employer does not give the contractor access to the site on the date agreed under the contract for a period, but notwithstanding not giving access to the site on the agreed commencement date under the contract, the contractor does not have the labour available, the resource available to actually start the work on that date in any event. So there are two causes of delay. Not giving access to the site is a relevant event, whereas not having the relevant result, well, the required resources to commence the work is a contractor risk event. And both of those are equal causes, arguably, of what the delay that's being caused to the completion date for the works. So how do the courts approach concurrent delay? Leyland Shipping and Norwich Union Fire Insurance, this is a very old authority. We're going back over 100 years. And this is referring to a proximate cause approach. And the approach here is to look at actually what is the prominent cause of what's actually causing the delay. This has since been superseded, and the reason for that was given in Adyard Abu Dhabi and SD Marine Services, and in the discussion in that case, it was identified that the dominant cause approach was viewed as artificial and arbitrary to choose one from perhaps two competing causes of delay. So sort of holding aside what perhaps might be an employer risk event, because it's held that the contractor risk event is of more significant causal potency. So in this, in Adyard, it was said that a useful working definition of concurrent delay is a period of project overrun which is caused by two or more effective causes of delay which are of approximately equal causative potency. This definition was taken from a paper by John Marin QC in 2001 and has been referred to subsequently in cases. So the key to what this is identifying is that we're looking at the period of project overrun, so that is the relevant period of delay, and that that is being caused by two effective causes of delay at the same time, and those two causes are of equal weight. So both of them on their own would have caused the period of delay to the completion of the works in isolation. So the period of concurrency is the period that those two effective causes of delay are causing delay whilst they overlap. If say you had a situation where there are two delays occurring at the same time, but their effects are felt sequentially, so one after the other, issues of analysing entitlements due to the problems arising from concurrent delay, they wouldn't really arise, because each of those delays could be assessed independently under the extension of time provisions under the contract and the liquidated damages provisions. So it doesn't cause the troublesome causation issues that concurrent delay cause. So Henry Boot and Mal Mason, this is the leading authority currently on how the court is to treat concurrent delay. It was held that if there are two concurrent causes of delay, one of which is a relevant event, so an employer risk event, and the other is not, the contractor is entitled to an extension of time for the period of delay caused by a relevant event, notwithstanding the concurrent effect of the other event. So what was held in this case is that the contractor is entitled to the extension of time for the delay caused by the employer risk event. For instance, in the earlier example, not being given access to the site, notwithstanding a contractor risk event, i.e. the contractor not being able to get its labour or plant to site in time to commence. So they will get the time despite the fact that if the employer risk event had not occurred, so if they had been given access to the site at the beginning, they would not have been able to complete, they would not have been able to start the works on time in any event. So this is often seen by employers to be a little bit unfair and a bit too absolute. Now, the reasoning behind this decision was based on the wording of the extension of time provisions in the contract in question. So if we're looking at the JCT contract and we're looking at clause 2.25, the thinking was that this is providing for employer risk events called relevant events under the contract. And if a relevant event occurs under the contract, the contractor is entitled to an extension of time for the full effect of that relevant event, notwithstanding the employer or the contractor risk event, so the contractor not being able to carry out the work in the example, because that entitlement is freestanding. So what does Malmaison mean, and what would its significance be to you? Where there are two causes of delay on a project, one at the risk of the employer, the contractor is entitled to an extension of time for the periods that those delays overlap. So this is what I mentioned. However, this does not mean that the contractor is entitled to recover its loss and expense incurs during that period. The reason for that is that the contractor's entitlement to claim loss and expense, so that's delay damages for from the contractor for from the employer for the works being delayed for a period, requires the contractor to prove its losses. Now, to prove its losses, it needs to show that a relevant matter, so an event that's at the employer's risk, has actually caused it to incur financial loss. Now, if the contractor has not been able to carry out the work in part because of a contractor risk event, so in the example, it not having the resources available, the argument goes that the contractor cannot demonstrate it has suffered any loss because it can't show that but for the employer risk event, no financial loss, well, it would have incurred it would have been able to carry out the works as planned, and it would not have suffered that disruption. So that's a causation issue. In the wake of Malmaison, some believe a more flexible approach should be taken in respect of concurrent delay in circumstances where blame could be apportioned between the parties fairly and reasonably, taking into consideration the culpability and significance of each delay. So, as I mentioned, the Malmaison approach to assessing periods of concurrent delay where the effects of an employer risk event and an contractor risk event overlap is that for the employer risk event, that event still entitles the contractor to its extension of time, despite the contractor being culpable for the contractor risk event, which is an absolute solution. And what's been suggested, certainly in a Scottish case that we'll mention in a moment, is that it would be more reasonable for an apportioned approach to be taken with regard to either the contractor's entitlement to the extension of time or the employer's entitlement to levy liquidated damages. And so the effects would not be the contractor is entitled to the full extension for the period of concurrency, and there would be a balancing up exercise carried out by the contract administrator. So the Scottish case I mentioned a moment ago, this is City in Shepherd Construction. And this decision was in favour of an apportionment approach when an employer is considering an application for an extension of time where there's been a period of concurrent delay. But this was firmly rejected by Mr. Justice Aikenhead in Water, Lilly and Mackay in 2012, which is perhaps the most recent case which has stood square behind the Henry Boot and Malmaison decision. In his judgment, he said, "I'm clearly of the view that where there is an extension of time clause, such as that agreed upon in this case, and where delay is caused by two or more effective causes, one of which entitles the contractor to an extension of time as being a relevant event, the contractor is entitled to a full extension of time. The fact that the architect has to award a fair and reasonable extension does not imply that there should be some apportionment in the case of concurrent delays. The test is primarily a causation one. It therefore follows that although of persuasive weight, City in case is inapplicable within this jurisdiction." So when we talk about what the courts currently hold in England, Henry Boot and Malmaison is still the leading authority, and for periods of concurrent delay, we are thinking time for the contractor, but not money, or at least not necessarily money. But bear in mind, we are only referring, when applying that principle, to the period of true concurrency of two effective causes of delay, which is quite a high hurdle for a contractor to establish that there are, in fact, two effective causes of delay running concurrently. So if it can be seen that the outcome of Henry Boot and Malmaison is perhaps not an outcome that an employer would be wanting to bear, or indeed a contractor with its subcontractor, then there's good reason for the employer to want to try and address the problem of concurrent delay in the express terms of its contract. And in the case of North Midland Building and Silent Homes, this was a case where there was in fact an express clause providing for periods of concurrent delay. And in this case, first of all, before Justice Fraser in the Technology and Construction Court and the High Court, and then subsequently in the Court of Appeal in 2018, this clause was upheld as being effective. And what does that mean? In this case, the clause stated that where there is a period of concurrent delay, so that's two effective delays, one caused by a contractor risk event, the other by an employer risk event, that's the employer would not be liable to grant an extension of time for the period of concurrency. So it reversed the outcome of the Henry Boot and Malmaison decision. And the argument that was run by the contractor was that this clause was contrary to the prevention principle. The prevention principle is a long-standing principle that's applied in different circumstances, but I mean the gist of it is that if an employer causes a delay, it can't then hold a contractor to the completion date under the contract, because it would be unfair for it to do so. And so if it causes a delay and there isn't provision in the contract for the contractor to get an extension of time for that cause of delay, then time is put at large. The argument that was raised in North Midland was that if there is a concurrent delay, so there's an employer risk that is causing a period of delay to the contractor, it would be contrary to that prevention principle if the extension of time was not awarded. That was rejected by the Court of Appeal, and it held that the prevention principle does not hold some special status as something that cannot be overridden by clear contract terms, and it was found that the contract terms were clear and straightforward and could be easily understood and applied to the circumstances. That was a part of the risk allocation in the contract between the employer and the contractor. So that might be food for thought, whether or not to include a concurrent delay clause in your standard terms, or if you're being posed with those, what sort of problems that you could potentially face, perhaps in circumstances where an employer risk event, say, incredibly inclement weather, preventing works on site. If that delay is concurrent with a delay that's held to be your responsibility as a contractor, perhaps, say you're not able to bring sufficient labour to the site or not able to procure materials, then despite that those weather conditions perhaps being an employer risk event, you're not entitled to any extension of time at all under this concurrent delay clause. In any event, if it's spelt out expressly in the contract, you'd hope it would at least add a layer of certainty. So on to the next topic. who owns the float? So what are we talking about when we're discussing float? This is, I suppose, the leeway in the program for any given activity for the contractor to carry out that activity without delay to that activity actually causing critical delay to the completion of the works. So contractors will often allow some float in a project program in order that they can absorb some delays which might arise as the works are proceeding. And this can provide a cushion to absorb the negative effects of delay. But where there is this float built into a contractor's program, obviously they would like to retain that float in their program to provide them with that leeway, so they have a bit of space to move in terms of achieving the completion date. By the same token, the employer would like to claim that float in the event of it being culpable for causing some delay, so it can hold the contractor to the agreed completion date under the contract. And so it doesn't necessarily have to award an extension of time, perhaps in circumstances where it's instructed variations to the contract works. So how has the float been dealt with? So this part's just dealing with when the float becomes a live issue, and that's to absorb delay, seeking extension of time, instructing variations, etc. So the contractor's response is, like I say, the float's been built into the program to afford it flexibility for unforeseen delays, so it will be covetous to keep hold of that float in its program, and that it doesn't exist to allow the employer to avoid granting extension of time. And the contractor will say that it should be afforded the right to freely manage the sequencing and timing of activities to avoid incurring delayed damages by completing the work late. There's, again, a lack of authority for how the float is being dealt with by the courts. But one case we can look to is Ascom Contracting and Alfred McAlpine Construction. And this concerned a construction project on the coast of the Isle of Man. Ascom were a specialist reinforced concrete contractor, and Alfred McAlpine were the main contractor for the works. In this case, Ascom claimed that their works were delayed as a result of flooding to the site from seawater, and that it was Alfred McAlpine's responsibility to ensure that the site was free for it to carry out the works. Alfred McAlpine counterclaimed, and a part of its counterclaim was for loss of its float under its main contract with the employer. And so what had happened was Ascom were in delay, and as a result of that delay, it had a knock-on effect on Alfred McAlpine's program for works. And as a result of that, Alfred McAlpine had lost the float that was built into its program, so lost that leeway. So what was held in that case? It was held that a main contract had the benefit of float built into its contract with the employer, but the employer also had the benefit of that float, and effectively the float was was in the possession of both parties. So Alfred McAlpine was prevented from recovering its hypothetical loss from from Ascon because it benefited from the float under the main contract. And like I say, the court's approach in that case was the float was a resource to both parties on the project. And I think a key thing when talking about float is that it's very relevant to when we are arguing about whether or not a contractor risk event or an employer risk event is causing critical delay to the works. Now, if an activity under a program of works has a certain amount of float cooked into it, then the fact that that activity has been delayed is not going to be causing critical delay until that float has been used up. And this is a part of analysis which I think is often lost in arguments over entitlements to extension of time. And that's the need to demonstrate that the employer or contractor risk event has caused critical delay, i.e. delay to the completion date of the works. So how do the standard forms deal with the float? Well, typically they're silent on it. When considering the float, we're dealing with questions of causation, and that's causation of delay to activities. However, the new FIDIC form is an example of standard form which does now provide for float. The red, yellow and silver book state the contractor owns the float and is entitled to an extension of time where the planned completion date is delayed, irrespective of any available float. And I think to many contractors that would seem like a more satisfactory solution, because they've priced the work on the basis that they would have that amount of leeway in their program to get the works completed, and that if their works are delayed by an employer, that employer should not be able to avail itself of the float that they have in their program. They should be given an extension of time to preserve the float. But in any event, as with concurrent delay, it could be said to be prudent for parties to deal with float expressly when negotiating their contract terms, and for those terms to be set down in the contract. So a few quick thoughts on proving delay. And this is never a straightforward task, and will always go back to the quality of the contemporaneous site records that are maintained, well, the contemporaneous records that are maintained by both parties during the course of the project. Much time has been spent talking about the relative methods of different types of delay analysis and delay analysis techniques, but as Wilcox Jay commented in Skanska Construction and Egger, sophisticated delay analysis is only as good as the data that's put into it. So that's the information that can be taken out of the records that are maintained, and the court will unlikely be impressed by a full report using sophisticated computer programming unless facts can be proved that establish the truth of the assertions that the party seeking either the extension of time or to claim liquidated damages, what they are seeking to put before the tribunal. So contractors would tend to prefer delay to be analysed on a prospective basis, and in fact the JCT form and the NEC form both now are set out on the basis that contractors, when before delay events occur, that they are requesting the extension of time based on a prospective analysis. And when we say a prospective analysis, we mean when we know what the delay event is and we are estimating what its effect on the rest of the programme will be. In fact, under the NEC form, the contractor is obliged to make prospective assessments of the delay effects of compensation events. The NEC speak for relevant events. And the project manager is obliged to award extensions of time on the basis of those prospective assessments as the works progress. And the thinking behind this is so that delay events are dealt with as the works are ongoing. When I say that contractors tend to prefer prospective assessments, that's because at the point that the delay event is impacting on the project, and the contract administrator is having to make an assessment of what the contractor's entitlement to an extension of time is, when it's looking forward into the future, all it can really look at is the planned programme for the works and how the activity in question is going to be delayed by this issue, in all likelihood, holding all other things equal. But that it is a hypothetical basis, because at the time that the delay event is being felt on the project, it just can't be known with any certainty to what extent the contractor's operations are going to be delayed by that event. And also how effective any measures that the contractor might be taking to mitigate delay. And it is an obligation under standard forms of contract for the contractor to take reasonable steps to mitigate the effect of relevant events on the project. And North Island Housing Executive and Healthy Buildings, this is an often quoted case concerning the court's preference for retrospective analysis. So that is an analysis looking back at what actually happened on the works and assessing what the contractor's entitlement to an extension of time is based on the things that happened after the relevant event, rather than looking forward after the relevant has occurred as to what its likely effects will be. This was under an NEC 3 form, which especially provided for prospective analysis. And the judge in that case said, why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them? So the judge was presented with prospective delay analysis carried out during the works, after the works had already been completed, and the response to that was, well, I don't really want to be looking at this hypothetical analysis when I can actually see what happened from the factual evidence of the case. I think anyone who's working under NEC 3 forms, well, perhaps would be aware that there is some conflict in its requirement for parties to submit their claims for extensions of time, and for the project manager, so that the contract administrator under the NEC speak, to assess the entitlements to an extension of time as the works proceed, because the reality is that project managers are invariably unwilling to award extensions of time, or at least extensions of time reasonably, where delay events, the effect of delay events are just not known. And what I've found is more often than not, they won't be awarding extensions of time on that prospective basis. And so where the NEC 3 contract expressly provides that they should be awarding extensions of time on a prospective basis, for the court to be holding that it doesn't actually want to assess the contractor's entitlement to an extension of time on a prospective basis would rather seem to conflict with what the contract is seeking to achieve, because arguably the employer could benefit from not awarding extensions of time during the course of the work as it's meant to, and in breach of its obligations under the contract, because it considers it would be in the best position to deal with delay at the end of the project when all the facts are known, and when in all likelihood, due to perhaps mitigation measures taken by the contractor or whatever else, the contractor's entitlement to an extension of time will be rather less when looked at on a prospective basis, well, on a retrospective basis. So, in conclusion, the courts are likely to prefer a retrospective analysis of delay based on factual evidence that's in front of them. So, impact as planned analysis, I'm sure this will be a method that many of you would be familiar with. It's pretty much the most straightforward way of analysing the impact of a delay event, and this is where you take your original as planned program and just on it impact out the event, the effects of employer or contractor risk events on the program, showing the extent to which they have hypothetically caused critical delay. And then the cumulative effect of these events seem to be the critical delay for the project. Obviously, that's a rather simplistic way of approaching it, and you can encounter difficulties with demonstrating cause and effect when adopting that approach, and also it brings into question how contractor delays are dealt with. But anyway, there are various different forms of delay analysis that are available, and the appropriate selection for a contractor will very much turn on the quality of records and evidence that can be presented to a delay analyst to review. And I mean, if the records are of such a standard that it can be established through regular progress reporting, regular updating of an as-built program as the works are progressing, or whatever else, then it might well be the case that disputes over delay are just far less likely to happen, because the argument is less likely to be seen as fruitful ground for perhaps a difficult employer who's unwilling to grant extensions of time for whatever reason. So, conclusion. Where an employer risk event causes a delay which affects the critical path, then an employer acting reasonably should grant the contractor an extension of time. This is the basis the contractor submits clear and reasoned information in a timely fashion. And so in dealing with issues of concurrent delay, I would recommend, first of all, serious consideration as to whether there is, in fact, true concurrency of two effective causes of delay, because, like I said at the beginning, in reality, these sorts of circumstances are very unusual. And then looking at what the contract provides for your entitlement, perhaps to claim an extension of time, or perhaps the liquidated damages. The Henry Boot Malmaison approach, that's time, not money, for periods of concurrent delay, and that's still the main authority. So if there are any questions at all on issues arising from this, and I accept full well, it's not a straightforward topic to discuss. There are whole books written on the topic, and there is not clear authority still on many of these issues. But any questions at all, do feel free to ping me an email. We've got some further events coming up, just featured at the end of these slides, which I understand will be available to everyone. And we're also available on this number. I understand there's some questions, Julie.
There are indeed. And just so you know, Jack, we had a problem with your slides. I've been trying to fix it, but we're still stuck on the front slide. So luckily,
no.
it's fine. I think everyone, there we go. Now they're moving, typically. Okay, that's fine. We've got some questions anyway. So one of the first questions here is, if a client delay and a contractor delay are both impacting on the planned completion, and the contract has been amended to say that in such a situation, no EOT is to be awarded, what if, I've lost the end of the question. What if one of the events has a greater impact than the other?
Well, I suppose this is going to the dominant cause issue. If when you say it has a greater event than the other, if it has a greater,
if the contract is silent on, if the contract is silent on whether the dominant delay takes precedent, does the amendment mean that it doesn't matter if one delay is longer than the other, and so no EOT is to be awarded?
If one delay is longer than the other, then there's not going to be concurrent delay for the period. There's not concurrent delay. I mean, if there is not, once the period of concurrency is over, the further resulting period of delay for the P delay will be dealt with as usual under the contract. Concerns about concurrency are only really concerns for the period that there are two delay events of equal causative potency, and that they're running at the same time. Once they're apart, and perhaps the more significant delaying event is just causing the delay on its own, then say if that's an employer risk event and the contractor is looking for an extension of time, then you will just be looking for an extension of time and loss and expense for the resulting period. So, I mean, if we're just talking about two delaying events where one of them is causing a longer period of delay, for the longer period of delay where there's not the concurrency, then the issue of concurrent delay isn't really present.
Okay, another question here. When the employer assesses the contractor's entitlement to an EOT, say 4 weeks, can they set off the period of concurrent delays caused by the contractor, say 2 weeks? Essentially, the contractor's net entitlement will be 2 weeks EOT, provided the delays are caused by different events.
I mean, it will depend what the contract provides, but I mean, if the contract is, say, an unamended JCT form, then if there is, we're talking about a period of concurrency for and a consideration of awarding an extension of time for that period of concurrency, then the Henry Boot Malmaison principle would apply, and that would be that the contractor is entitled to the extension of time for the full delay caused by the employer risk event, but not to the money for loss and expense.
Right.
However, if it's amended, perhaps, I mean, you see them far more frequently now, amendments of the sort discussed in the North Midlands and Swadling case, then that can reverse that situation. It depends what the parties agreed.
Okay. That's great. That's the questions done, which is fantastic. So thank you everyone for attending. Thank you, Jack, for your time. Apologies to all for the problem with the slides. I promise to poke them with a stick.
I'm very sorry.
Poke them with a stick in the meantime. When your CPD certificate email comes out, you will be able to download these as well. If you do have any questions for Jack, as you can see, his email is in the slides and his email is on the website and it is on the screen there. He's more than happy to answer any specific issues you've got. So, okay, that's the end of our presentation for tonight. So thank you very much, everyone. Thank you, Jack, and we hope to see you all again soon. Thank you.
Cheers. Bye then.